Hello, and this week on RTL Today, I'm very happy to welcome back our two lawyers, Louise Benjamin and Graham Wilson. More about their work on the link next to this video. We're going to continue the theme of bankruptcy, which is a very serious matter, and it is likely that during this period of coronavirus, where the economy is rather unstable across the world, we may see more bankruptcies. And so from a legal point of view, it's always good to know more about it. This week, we're focusing on sole traders. We will also have more information on force majeure and some frequently asked questions at the end. So Louise, we're going to dive straight in with you. Could you first of all explain to us what is meant precisely in Luxembourg by being a sole trader?
Well, thank you very much, Lisa, for having us. The Article 1 of the Commercial Code already describes what a sole trader is. So, sont commerçants ceux qui exercent des actes de commerce et en font leur profession habituelle. So, somebody who carries out their usual business and commercial acts in their own name. So, in the US, you'd call it a sole proprietor. And in the UK, you might call it a sole trader or an individual enterprise. A sole trader is a business form where the entrepreneur or the skilled craftsman, the trader, finances the business himself and makes all the business decisions alone. He carries out the business activity in his own name. He does not have any legal personality, as the entrepreneur and his business are not two distinct entities. He assumes full responsibility vis-à-vis third parties. In particular, he commits his personal assets.
Well, this is very important.
Yes, that's the important part. The income of the business is allocated to a single person, the entrepreneur, and he privately withdraws money from his own business. So if he needs cash to buy his own car, then he withdraws money from his own business. It's trading in your name without a corporate structure. You do need a registration number. You might need a trading permit. And you should, as much as possible, keep your personal and trading business separate. You should have separate bank accounts, separate paperwork. The more you can do to separate it, the better. For example, you might be having your address at home. You might be carrying out your business from your home address. You might even want to have a part of your house which is set aside. But then you should be careful about that as well, because one day when you sell your house, there might be some tax consequences if it's not your if it's your main residence, but a part of it is for your business. You should be careful about that.
Yes, that was something so interesting that I didn't know. I mean, I fall into that category, and I'm sitting in my little office here, and it didn't occur to me that if I owned this house and if I was to sell it, my office is not part of my residential abode.
Well, it depends, of course, if you actually deduct, if you make it a deductible part of your business.
Tax returns.
Yeah, the tax return.
Yes,
exactly.
It's something to be aware of. When we think about bankruptcy for a sole trader, what would be the tests that one would need to run to think if one was in trouble?
I think if you're thinking about the business being in trouble, then consider always the two-prong test. Can you meet your debts as and when they fall due? Can you pay your bills? Can you raise credit? So let's say you can't necessarily pay your bills. Can you raise credit? Can you borrow some money from family or friends? And if the answer to both questions is no, then perhaps you should be thinking about bankruptcy. I mean, it is extremely hard to be a personal trader. And at the end of last year, the Chamber of Commerce, the Luxembourg Chamber of Commerce, noted also that the cost of working and tax should be at the center of political discussions. And I would imagine that after COVID-19 that they will be. It's not easy to run your own business. You need to, Luxembourg needs to consider tax feasibility and renew dialogue and confidence so that people can want to be a sole trader, or in fact, they should perhaps be setting up some kind of company around themselves to protect themselves. You could end up in a situation of stigma otherwise. And it can run into your personal assets, and it's different from, say, a company which might give you some protection from creditors.
And that's the line we're trying to figure out today. So could you just talk us through, firstly, the steps related to how one would walk through bankruptcy if one was a sole trader?
Well, I think last week Graham already outlined some possible options, which might be controlled management, suspension of payments, seeking a scheme of composition with your creditors. But let's actually look into bankruptcy, because that would probably be the most likely scenario. There's also a collective debt settlement procedure for individuals, but that probably wouldn't apply to a sole trader until a number of months after your commercial debts have been dealt with. So in order to file for bankruptcy, you must be obviously a trader, and you must have ceased payments. You can't pay your bills anymore, and there must be a debt of a fixed amount that you actually need to pay and you can't. And you've lost credit worthiness. I said before, you can no longer get a loan from anyone. And then you should consider filing for bankruptcy. And at the moment, it might be slightly more difficult to file for bankruptcy during COVID-19. But you should definitely take some advice and start preparing the documents. And so you might want to file for bankruptcy with the competent district court, in particular where the business has its registered office. And you need to prepare all the paperwork. And you can also call the court clerk, and usually you can make an appointment to go and see him. Obviously, at the moment, it might be slightly different. And I mean, you are legally bound to start the bankruptcy procedures if you can't pay your bills and you can't raise funds. But it's also possible that one of your creditors might start the bankruptcy procedures. He might go to the court and ask for you to be put into bankruptcy.
Which was the same as last time with the corporate business bankruptcy.
Yes. If the criteria for bankruptcy are met, the court will issue a declaration of bankruptcy. So what would you actually need to prepare for this moment? You need to go along with your ID card and details of your address. You need the balance sheet of your business, or you need to explain why you can't provide the balance sheet right now, but perhaps you can provide it shortly. You need to certify and date it, and you need to include a list and valuation of all your assets, so movable and immovable assets of the business. And you need to put forward a statement of accounts, receivable and payable, profit and loss table, and expenses table, as much financial information as you can, or an explanation of why you can't produce it right now and when you will be able to produce it. You might need to produce all the books of the company and make sure you've complied with double entry bookkeeping, and ask the clerk to give you a receipt for all these documents. And if necessary, if the next day you think of something else, you can add it the next day. It doesn't matter that you haven't added it on the first day. Try to be as open as possible, because if you don't, you must give everything within the legal deadlines.
So last week and this week, what we're hearing over and over again is the necessity to have very, very clear financial bookkeeping always as an absolute priority of business procedure.
Exactly, Lisa. Yes. The court will issue a declaration of bankruptcy, and the date that the judgment is delivered, it will have retrospective effect starting at midnight, even if the judgment has been appealed or opposed. And there'll be a trustee in bankruptcy who will be nominated, and that will usually be a lawyer, and a bankruptcy judge who will supervise the whole affair. And the judgment will set the dates of cessation of payments, which will be in the past. So they might look at the last 6 months of what you've been doing. And following the judgment, the trader, so the sole trader, loses all administrative powers over their assets. So all powers are transferred to the trustee in bankruptcy, so the lawyer that's been appointed. He takes on all your administrative powers. So you can no longer sue or be sued, except for certain exemptions. And then they look at what's called the suspect period. So that when the bankruptcy was started and the date was named in the past, for example, the last 6 months, and that's called the suspect period. And the trustee will look at everything that happened in those past 6 months. and to check there hasn't been any misconduct. And he can even, the trustee in bankruptcy can even cancel some of the contracts that were done during that suspect time. The trader also can be held liable or whatever. So the bankrupt trader, if he goes out and makes any payments after this, they will all be null and void. There will be some exceptions for creditors. So creditors who have special preferential claims, for example, if they have a mortgage or they have a special pledge, then there will be some exemptions for creditors to take action. And then the other thing you must know is that judgment is published in the local newspaper. And also information on the bankruptcy is also published on the Luxembourg Business Register and on the Luxembourg Bar and the Diekisch Bar. Then you come to the next stage, which is, well, once the trustee in bankruptcy has looked at all your contracts and all your payments, all information from creditors, because obviously creditors are invited to submit their claims. The trustee in bankruptcy will check that all these claims are correct. The judge that was appointed at the beginning will supervise all of this, and any contracts that the trustee wishes to finish will be finished. And as I remind you, the trustee is also a lawyer who's been appointed. And then finally it will be closed. And the trustee will summon the creditors to a sort of a presentation of the accounts, and the trustee will make a proposed distribution of assets, file a motion to the judge to ask him to close the bankruptcy. But all of this can take really quite some time.
Mm-hmm. And during that time, of course, this is just the litigious part. There's a huge emotional weight, mm-hmm. which we won't speak about today, but it's a very difficult position to be in.
Graham, yes.
Graham, last time we spoke briefly about force majeure, but I think you have a little bit more that you might want to say to us. In the UK, we say force majeure in a contract, otherwise it doesn't apply, but things are not necessarily the same here in Luxembourg.
No, Lisa, that's absolutely right. I really mentioned it very briefly last time, but a couple of friends of mine did say, why didn't you say a bit more about force majeure, especially in the present circumstances with coronavirus. Before I say that, can I just say one thing about the sole trader? As I mentioned last time, essentially the bankruptcy of a company and the bankruptcy of a sole trader are the same. So the steps that Louise has been talking about, which are in more detail than in the first one, they apply pretty much in exactly the same way with a corporate bankruptcy. The only thing which is, I think, quite maybe quite obvious to people is that it's bad enough when it's a company bankruptcy, but when it is bankruptcy of a sole trader, it's very intrusive. And you're stepping over the line often between, or the trustee in bankruptcy, stepping over the line between what are business assets and private assets. So it's difficult there. But force majeure.
I suppose you there, because I think sole traders often wonder if they should create a company.
Oh, absolutely. I mean, I think that I think you have to, it comes basically, I think, down to often to questions of cost. But yes, I mean, you have to really think very carefully about that. And you do certainly get a certain amount of protection from a company. One of the difficulties is that, for example, if you're borrowing money from a bank, if you're a sole trader, you're personally liable. If you're operating in the form of a company and you're the shareholder and the director, the bank may anyway require a personal guarantee. And if you are in business with suppliers, for small businesses, small companies, they may require a personal guarantee before they'll do business with you.
So it comes down to the same thing.
It's not always as easy as that.
Yeah.
It's something that you have to look at carefully. And as we spoke about before, in terms of certain tax liabilities, social security questions, a director of a company, who's not necessarily the same as a shareholder, of course, although they often are, they have certain obligations as well, which are not exactly unlimited, but wider. So it's not an easy thing, and you really should take make careful thought and take advice on it, and from your banker, from your lawyer, from your accountant, from the Chambre de Métier, from the Chamber of Commerce. There's a lot of places where you can get advice. The other thing that
so traders don't always have access to all of these people, so it's good to.
It's expensive, isn't it? Yes. When you're first setting up and you have nothing, then obviously it's expensive to do all these things. And as Graham said, it doesn't always protect you 100%.
Well, whenever you start a business, the problem is the costs are all up front. You've got a lot of fixed costs, and you've got no income to start with. So yes, these are not easy decisions.
There was a lot of help in Luxembourg for startup.
So just returning, Graham, to
force majeure.
Yes.
Right. So as Louise just mentioned, this is although force majeure is known under English law, it's really more a creation of the civil law system, dating from when we talk about the civil law system, we talk about the Napoleonic Code, which dates from 1804 in France and has been mirrored in Luxembourg, in Belgium, and in many other countries. So you have a codified form of law. In other words, the law of the land is written out in a code, not like in the English system where it's more common law, what we often call judge-made law. Of course, you also have a lot of statute law. I mean, a lot of law about digital protection, etc., etc. That's not in the civil code. That's separate statute law that's made on an ad hoc basis by Parliament. But it's a fundamental body of basic law, and if you like, also a way of thinking. So in there are a number of provisions in the Luxembourg Civil Code which refer specifically to force majeure, and the most basic one is Article 1148. So what is force majeure? It's an occurrence that's unpredictable, could not have been avoided, and is outside the control of the contracting parties. So it's external, unforeseeable, and irresistible. And coronavirus looks awfully like that. And in fact, when you look at some of the texts around, for example, partial unemployment, chômage partiel, specific references to force majeure, not to the specific Article 1148, but the principle of force majeure is the basis for this. But it doesn't just change or modify every contract, because as well as being external, unforeseeable, and irresistible, it must have a direct impact on impeding or precluding a party's ability to perform under the contract. So I was trying to think of some examples, but if, for example, you'd ordered a new car before coronavirus, and now you said, well, I don't want to take delivery of that car. It's coronavirus. I can claim force majeure, cancel the contract. Almost certainly not, because it hasn't actually dealt with either the buyer or the seller, their ability to deal with the contract. If that had been a restaurant delivery vehicle, may be different, because your business is no longer what it was. So it's not just the fact that the coronavirus has happened, but it had to have a direct impact on your contract. So that's in the civil law, and you have to therefore look at the contracts that you have and say, do I want to keep this contract? Do I want to get it modified in some way? Do I want to step out of it? Can I argue that force majeure would allow me to do this? And it might reduce my contractual liabilities. There's not a lot of decided cases in Luxembourg about that. There are some in French law, and cases have decided in French law that Ebola counts as force majeure. You may have heard of chikungunya. It's a mosquito-borne disease which is very prevalent in Réunion and in some of the other French colonies. Colonies, sorry, wrong word. Dom-toms. That is decided. That is not force majeure.
Oh, why? Why is Ebola?
Because it's not life-threatening. It doesn't. It may meet the test of external, yes. Unforeseeable, no. Chikungunya is pretty well known. Irresistible, unavoidable, no, not really. And it's not a fatal disease.
Some might say coronavirus is not a fatal disease, depending on who one is.
Correct. No, correct. But there is a case, actually, there's a French case from Colmar district in France, from March 2020, the Court of Appeal, where it's actually it's not a contractual case at all. It deals with an immigrant's inability to attend at a tribunal hearing where their immigration was being determined whether it's lawful or not. And they couldn't attend because of the coronavirus, and they therefore hadn't met their obligations, but they were excused because of the effect of the pandemic. But the court said the pandemic alone is not sufficient. It has to have a direct impact on what you're considering, the contract or whatever. Now, I know this is not supposed to be, I just thought it was quite interesting to say, there is an equivalent in Chinese law, but that requires the issue of a certificate by the state saying, this is force majeure. Don't ask me to tell you how they say that in Mandarin. So you get a state certificate, and and many thousands of these have been and are being issued at the moment in China.
Right, but
and the similar certificate was issued in the SARS epidemic in 2002. So this is not a peculiarly European idea, force majeure, but it's a very complex subject, because when you mix commerce and humans together, of course, you get an almost infinite number of circumstances. And while you may have the pandemic itself, which meets the three basic criteria, how that has an impact on the contractual relations is more difficult. Also, although the provisions for force majeure are in the civil code, you also have the competing idea of a principle of freedom of contract. So parties, as long as they're not doing something illegal, can contract to do anything. And so you can contract out of the provisions in the civil law, or you can modify them. So it's something where it's not just, well, there's something in the civil code that says force majeure applies, and therefore my contract can be torn up or whatever. You have to analyze it. And the language is difficult, not because it's French, but contracts don't always make it clear what they mean, and they use words and phrases rather interchangeably. So you often find contracts, and they say force majeure in a clause. They refer to impossibility. They refer to hardship or frustration. So you've got to then analyze what the parties meant when they contracted. Now, one of the things why it's interesting in Luxembourg is there's no equivalent to force majeure in English law, not as a basic principle.
What about an act of God? We sometimes hear this phrase.
Yes, well, that depends whether you're an atheist or not, whether that applies, doesn't it?
We sometimes see it in contracts.
Yes, indeed. But that's more to do with what this is, again, in clauses which refer to, for example, material adverse change, which you get in a lot of financing agreements. So the parties then are saying, yes, there's some supervening act that has an effect. And so, but an act of God is not necessarily force majeure. Because, for example, if you think of an act of God as being typically a lightning strike, you'd be very upset if your house was struck by lightning and then your insurance company said, we're not paying out act of God. Sorry, that's exactly what I've insured against. So it's not, it's a little bit the same idea, is that you should look at it, but is it going to apply in your particular case? And maybe there's some contractual wording that's not quite the same. It's all really in the contract about allocation of risk, which party had agreed to take on, but force majeure explicitly is talking about something that was unforeseen. The partner, we didn't think of that. No, we've no idea what should happen now. So yeah, that's a bit more about force majeure. One thing I was having a little bit of look at. In English law, they have a concept of frustration, which was judge developed law, which basically says things have changed so much that you just tear up the contract. It's as if the contract had never happened. It's a very, very brutal way of dealing with things. Force majeure is more subtle. But there is a lovely case recently where a Brexit case where, you know, the what they call the European Medicines Agency, which has an office in London, they had a 25-year lease and they wanted to step out of their lease because they didn't want to be paying 25 years for an office they couldn't occupy. And they said, a frustration, kind of like force majeure. And the court said, no, it's Brexit was not a frustrating event. So I thought that was quite nice. We try not to apply. I mean, we know these podcasts are not for lawyers; they're for non-lawyers. So we try and keep the references to the law small.
Well, so what is the conclusion of that? Have they had to pay the 25-year lease? Will they have to pay?
Yeah, well, one of the things, of course, is what you can transfer a lease. A lease can be, although it's people in Luxembourg don't understand 25-year leases or 99-year leases or whatever, but you can sell them. It's an asset that you can sell. Often there'll be restrictions on transfer and things like that, but the problem when you transfer a lease is that they might transfer that lease to another business, but because they are still the original lessee, they're still liable under that contract. So if they transfer it to someone else and that other person goes bankrupt, for example, they would still be responsible. So it's possible for them to get out of it, but they wanted to just say, oh no, it's finished. It's gone. It's not our problem anymore. So they can still deal with it, but it's still their problem.
So just looking at some of the questions that we have, government help, what government help is available? Louise?
There's plenty of help available at the moment. So in that, from that point of view, we're very lucky. Look under SME, so small and medium enterprises, and look under also independent, and under COVID-19. I'm sure you probably all know it better than we do. There's plenty of information out there. I won't go through it.
And that
keep checking because it does change. It does change. It gets better.
Oh, that's good. It gets fuller and fuller with different yes. Updates.
Obviously, there's disappointment too, because not everybody fits within it, and then it can be quite upsetting also.
Mm-hmm. Yes. Another question here: how long does it take to close a bankruptcy, on average?
10 years? No, years. Yeah. What do you know? No, it can take a long time.
I mean, it's well, you've got to the curateur, the trustee in bankruptcy, has to realise the assets, and mainly that means getting cash for them, and not necessarily, and pay off the liabilities, and that can happen. That can happen very quickly. I mean, if you have something that is like a small cafe or restaurant, there are business. I mean, getting rid of second-hand kitchen equipment and things like that on the commercial is not easy, but you do have firms who specialize in buying it. So it could take, it's not going to happen in weeks and months, but it could all be done in a year. But if you've got long-term contracts, I mean, it may be that that there are some assets which, for example, say there was a piece of real estate. Today, well, with the COVID-19 problem, it may be difficult to sell something, and it may be actually better to wait a while.
We don't know which way prices will go.
No, exactly. No, I mean that's always a difficult problem, and it does depend. I mean, small businesses, you can deal with them rather quickly, but if you have a lot of employees, is it actually worth trying to keep the employees on, or some of them, for a while, to see if you can sell the business as a going concern? Because often the breakup value of business is less than the sum of the parts. So it's, you want to see, you may want to do that. So but I mean, you should be able to do it within a year or two, I would have thought. But yeah.
You can drag on, yes.
Which is a terrible emotional weight as well.
Mm-hmm.
The next three questions I want to kind of bunch together, because I feel we had a little bit of this last time when it comes to companies. Can I pay my partner a bonus before it goes under? Can I prioritize payments to my preferred suppliers?
No, neither, no.
Yes. And am I responsible?
Yes.
Well,
Yeah. Yes, I mean, if you're worried that your business is not going very well, you should be extremely careful as to what you pay out.
Mm-hmm.
And as we said in the beginning, don't make preferential payments to people, and let the court decide if somebody is preferential.
Yes, you both said this week and last week about the suspect period, which is very well examined too.
Yes, because it could be undone, any payments.
Now, you mentioned, Louise, today visibility. So another question here is, are my accounts available for everyone to see online?
If your annual turnover exceeds 100,000, excluding VAT, then I believe that it is available online. Mm-hmm. So other people can go and check what you've done.
And moving on to VAT or TVA, do I need to pay Social Security tax?
Yeah, so I think it's the same as we said last week. If you're going to prioritize anything, prioritize paying your VAT and your Social Security payments. So your own Social Security payments, perhaps, and if you have employees, make sure you pay, their salary taxes, their the Social Security part. That can really land you in hot water if you haven't paid it, because it's considered that when you pay a salary, that the Social Security already belongs to the state. Or the same with the VAT. When you're collecting VAT, you're not collecting it for yourself, you're collecting it to pay to the state. So make sure you keep up to date with those two payments.
Louise, the next question is a tricky one, and we mentioned it briefly last time, the stigma related to bankruptcy.
Yeah, well, unfortunately, some people might consider that there is some form of stigma attached to bankruptcy here, and it might stop you getting a trade permit in the future, or getting credit worthiness. In the UK, in the US, many people will set up businesses, startups, and they will not work. So in the US, you might set up 10 and only one of them works, and that's well considered. That's not a problem, because the number 10 will be amazing. And in Luxembourg, there is still some stigma attached to the bankruptcy for the reasons I just mentioned. But obviously with COVID-19, it's not really your fault, unless you had, and it might not be your fault beforehand either. It is extremely difficult to run a business. And as I mentioned earlier, that even the Chamber of Commerce said that this is an issue which we really, really need to raise. The issue of running sole proprietorship. Mm-hmm. So I hope that it will change. And Graham mentioned in last week's podcast that there have been draft laws from the past, and so we do hope that the bankruptcy laws will change soon to assist people.
On that point, I think some directives have been formalised in the last week. Graham.
Well, not quite formalised in the last week, but something that I maybe should have mentioned last time. But of course, we went on quite a long time, well, a bit longer than we originally were aiming at. Let me just come back to this question about the stigma. I mean, one of the difficulties is, almost by definition, when you have a bankruptcy, there's been a failure. I mean, and the individual feels that, but also in a small community, it's known, and it may be that typically within a small community, the clients and customers and suppliers have lost money, and because of that person's activity or lack of activity or whatever. So I mean, we're not talking at all about the question where someone has deliberately sought to mislead people and has participated in a scheme or set up a scheme, which with the end result of becoming bankrupt, so they can't pay their creditors. But what has also changed, I think, has been the the growth of the internet commerce. And we have seen in Luxembourg over the last 10 years a lot more emphasis on startups. In my experience, it has always been the case that it was rather difficult to start up a business in Luxembourg. And of course, you do need a certain amount of assets to start with often, even if it's only a place to work from or to sell your product from. The internet has made a huge difference to that. It's made it, in some ways, a lot easier to start up a business. And it has therefore put the idea of starting a business more into people's thoughts. But we know that a lot of, although we all see the big successes on the internet businesses, some of which have been closely associated with Luxembourg, we've also seen a lot of failures. But yeah, I think the other thing then, coming to what I wanted to just take a couple of minutes to talk about, was I had spoken briefly about these possibilities of helping a business where it's in difficulties, where composition with creditors, having a manager appointed. And what I didn't refer to, because we were talking really in the context of COVID-19 and today, is there is a directive, which is a European directive, which is, the directive itself is finalized, but it doesn't, the implementation date at its latest is July next year. Maybe this the current crisis will push that forward, and of course it would have a significant impact on the law project that I was talking about, 6539. But we got a lovely. The interesting thing about this is that when you look at a directive, there is a lot of background as to what they're trying to do and why they're trying to do it and how they're trying to do it. And because you can get it in all the languages, it's 38 pages of very, very dense text. But there's an awful lot of interesting information in there. Just let me read a couple of things. What they're trying to do is ensure that viable enterprises and entrepreneurs that are in financial difficulties have access to effective national preventive restructuring frameworks, which is exactly what we're talking about. And those frameworks should help to prevent job losses and the loss of know-how and skills and maximize the total value to creditors. So those are all very, very worthy expressions. They also concerned about the excessive length of procedures concerning restructuring, insolvency, and discharge of debt. And two other things which are enshrined in the law itself. One is that member states shall ensure that the period after which insolvent entrepreneurs are able to be fully discharged from their debts is no longer than 3 years, starting from the time of insolvency. And also provisions allowing for the insolvent entrepreneur to be able to start business again, provided it was not a wrongful insolvency, provided that it was not an insolvency due to a criminal, effectively a criminal cause. So that directive, which, as I say, the final implementation date must be no longer than July 2021. I think has some very interesting provisions in it, and merits some careful study. Sorry, the legal text is the legal text, but the preamble is quite interesting for even normal people.
Even normal people. Coming back to even normal people. No, it all sounds very worthy. It's just with the law. I mean, what's coming back to me again and again last week and this week is that the wording of all of these contracts, it has to be so tight, so watertight, and every single phrase can mean something different depending on which legal system you're looking at or even which language you're looking at.
Just one thing which came up last time was the question of free legal advice. So now when we're in the realm of sole trader, you can there is the possibility for what they call assistance judiciaire, which is getting funds from the state to pay your legal costs. It is administered by the bar, so you contact the barreau. It is means tested, so they have you basically have to show that you haven't really got the money to pay your lawyer. But there is direct assistance available to getting to pay a lawyer to help you, not applying to a company, but applying to a sole trader, for example.
The next question, it's referring back to something we spoke about before, really. I'm thinking of setting up a small business. Should I set it up in my own name? You spoke to this earlier, the fact that it's still a slightly grey area, but obviously, there are pros and cons on both sides.
I think there's a couple of things to bear in mind. When we talk about a business in your own name, it doesn't literally have to be in your own name. I mean, but it is a business that is run by a natural person, in other words, an individual, rather than a legal person, a company. But in your own name, you could set up a restaurant or a cafe, and you could call that business the Corner Cafe, and that would be your trading name. But it's still you as an individual, unless you've actually set up a company. And if you set up a company, the company could be called XYZ SARL or XYZ SA, and it could carry on business as the Corner Cafe. So there's a difference between the trade name, in other words, the name that everyone sees, like Google, and the company that owns that name. And you have some companies that own many names. So you've got the trade name, and then you've got the individual who is the sole trader. So he or she trading in their own name, carrying on business as we say in their own name, but in fact it's in whatever commercial name they choose. What we haven't mentioned, for example, a sole trader can be carrying on together with another individual in partnership. We haven't mentioned partnerships, but it's more or less the same as a group of sole traders getting together. But if you are then an individual and you are going to carry on business on your own, you then also have to think very much about your family relationships. And if you're married, you should also make sure that you should seriously think about having separation of assets, because it's all very well if your business goes badly, but if the family home goes as well, that's not good. So you have to think very, very carefully. And this is something I think that people brought up under the code, the Napoleonic Code, Luxembourg, France, Belgium, think about a lot. Whereas English people often do not think about that. People coming from they don't always think about the matrimonial regime. And of course, we also have people who are living together, not married, civil partnerships, etc., etc. You should be very careful that what you or your partner or your spouse is doing doesn't get the other one into trouble. The intention, I think, is to talk next time about what happens to someone who gets in trouble themselves personally, who's not a trader. The kind of the last,
yes, we will.
The last theoretical possibility.
Sorry about that. The dog has woken up and was eating my receipts of all things.
That's a good excuse. That's just like my dog ate my homework. I mean, you tell that to your accountant. My dog ate my receipts.
My dog has eaten one of my daughter's books for school. Anyway, never mind. Different story.
There's one thing perhaps we should mention, which is which we will talk about next week. But if you are experiencing personal difficulties, you do have these 6 SICS in Luxembourg, which can help you. Service d'information et de conseil. So you have these special places that you can go to, SICS, and it depends where you live as to which one you can go to, and they might be able to help you with your personal indebtedness if you're getting worried. That is personal rather than sole trader.
Commercial, yeah.
Exactly, but they might, but as we mentioned that there's always an overlap as a sole trader, you might be very concerned and need some emotional support as well, and that's somewhere where you can go in Luxembourg to get some help.
We'll link to that in the end, but it sounds really like there's so much to consider, not even at the bankruptcy stage, but when you're actually at the onset of setting up a business. And I think that that's a really crucial question. to consider, first of all, do you set up as a sole trader, especially something to consider if you're likely to get married or are married, and then
or divorced, or likely to get divorced. Sorry.
Oh, the whole spectrum is a possibility. Thank you both so much for your professional expertise. Again, this is not legal advice. We have to say this every time. It is comment, observation, information giving, hopefully, and we will link to all of the things you've mentioned, further information attached to this video. Next week we'll talk about personal bankruptcy, so we're moving closer and closer to the individual every time. We have been smiling, but obviously each one of us knows that this is a very, very traumatic situation. If you have any final words, Graham, Louise, fire away.
Well, next time we'll be talking about the French phrase is surendettement, so over-indebtedness, because individuals who are not commercial do not go bankrupt. It's not like in the UK or Ireland. It's not a personal bankruptcy. Surendettement, and the French word déconfiture.
Thank you both.
That's it.
So much. We look forward to speaking to you again next week. Thank you.
Thank you very much, Lisa. Thank you, Louise.
Thank you.
Bye.
Thank you, Ben.